What up, YouTube? Here again with another video. Very informative. Informatory product. At it again. Okay, this is information. Okay, not legal advice. Again, this is information, not legal advice. If you need to require legal advice, please do seek so from one other than I. Okay? This is for educational and for your knowledge. Okay, start from the top. Congress findings and declaration of purposes. Informed use of credit. Commerce and Trade, Title 15. Okay, guys? I'm about to prove that everybody believe, like 90% of the world, or shall I say this country, population of this country, believe that they're operating a motor vehicle, or shall I say driving a motor vehicle. And there is a difference between a motor vehicle and a car, a motor vehicle and an automobile. Okay, there is. Please do your homework, do your research, and use discreet discernment. Okay. Just like a lot of us believe that we're driving a motor vehicle, most of us believe that we actually live in a dwelling. Or does that make any sense? Maybe I should put it another way. We all believe that we live in a house, but we're purchasing and paying mortgage on a dwelling. I think that's better. So there's a difference between a motor vehicle and a car, and there's a difference between a house and a dwelling. Which, under certain situations, you can call a house a dwelling. Basically, a dwelling does mean a house. Well, I'll show you. But again, informed use of credit. Okay, when I highlight words, I need you guys to keep those words in your membrane. Okay. The Congress finds that economic stabilization would be enhanced and the competition among the various financial institutions and other firms engaged in the extension of consumer credit would be strengthened by the informed use of credit. The informed use of credit results from an awareness of the cost thereof by consumers. It is the purpose of this subchapter to assure a meaningful disclosure of credit terms so that the consumer will be able to compare more readily the various credit terms available to him and avoid the uninformed use of credit, and to protect the consumer against inaccurate and unfair credit billing and credit card practices. Okay, avoid the uninformed use of credit. How does one avoid the uninformed use of credit? Let's find out. I don't think we can, but let's find out. Let's go on this journey real quick. I'm gonna try to make this video quick as possible. Shit, I don't like long videos myself. Okay. First of all, we have to know that banks cannot lend credit. Banks don't lend its own credit. Okay, they lend your credit back to you, and here's proof. Okay, you could just stop, pause, read, look it up, but there's gang of case laws to back it up. A national bank cannot lend its credit to another by becoming surety, endorser, or guarantor for him. Such an act is ultra vires. Okay. In federal court, it's well established that a national bank had no power to lend its credit to another by becoming surety, endorser, or guarantor for him. Okay. A national bank has no power to lend its credit to any person or corporations. Okay. All right, let's go back. Okay, this is extension of credit by Federal Reserve banks. This is how they get the banks get their credit. Okay. Okay, this part establishes rules under which a Federal Reserve Bank may extend credit to depository institutions and others. Okay, we're going to go down here. Extension of credit, generally, advances to and discounts for depository institution. We're not going to read one, you do the reading. I'm going to read two. 2. An advance to a depository institution must be secured to the satisfaction of the Federal Reserve Bank that makes the advance. Satisfactory collateral generally includes United States government and Federal Reserve Agency securities, and, if of acceptable quality, mortgage notes covering 1 to 4 family residents. Okay, 1 to 4 family residents, state and local government securities, and business, consumer, and other customer notes. This is how they're getting their credit. Keep this one in mind. Okay. So most of us in this country, if you have a mortgage, they issued you a 1003 mortgage application form. Okay. Why are they issuing only the 1003 mortgage form application? I don't understand. Okay, but here we go. The 1003 mortgage application, also known as a uniform residential loan application, is the standard form nearly all mortgage lenders in the United States use. Borrowers complete this basic form or its equivalent, Form 65, when they apply for a mortgage loan. Though some lenders may use alternative forms, okay? Though some lenders may use alternative forms or simply accept basic information from the borrower about their finances, the property type, and its value, the vast majority of lenders rely on the 1003 form. Property type, interesting. Just noticed that. Okay, let's find out what are those other the alternative forms are and why they're not being used, if there are any. Okay, we're going here. We're going to the Equal Credit Opportunity Act. Okay, we're going to stroll down here. You guys do your own reading research. I'm going to where I need to go. All right. Here's all the forms. Okay, guys. And that they should be using. And here is the 1003 form. Okay. Uniform residential loan application. This is the form that every one of us had filled out if you have a house. Okay. This is the beast. This is the monster right up in here. Acknowledgement and agreement. Hey, that's for another video. Okay, we're going back to the top. We are going back to the top. Okay. Model application forms. This appendix contains 5 model credit application forms, each designated for use in a particular type of consumer credit transactions as indicated by the bracket caption on each form. The first sample form is intended for use in open-end unsecured transaction. The second for closed-end secured transaction. The third for the closed-end transaction, whether unsecured or secured. Fourth, in transaction involving community property or occurring in community property states. And fifth, in residential mortgage transaction, okay, which contains a model disclosure for using and compliant with 202.13 for certain, okay, certain dwelling, mind you, This is very big. These two words. It's huge. For certain dwelling related loans, all forms contained in this appendix are model forms. Their use by creditors is optional. Okay? Their use by creditors is optional. So if it's optional, why are they only issuing the fifth one and not the third or the second? Okay? So it's blatantly, purposely done. Okay, so but when they're using the residential mortgage transaction, it has to be in compliance with 202.13. It has to be in compliance, okay? Let's see what that says. 202.13, information for monitoring purposes. So they're really telling us that they're going to be monitoring us. Amazing. All due to the fact that I have a 1003 mortgage application form. Interesting. Okay, a creditor that receives an application for credit primarily for the purchase or refinancing of a dwelling. Okay, look at that word again. Occupied or to be occupied by the applicant as a principal residence, where the extension of credit will be secured by the dwelling, shall request as part of the application the following information regarding the applicant. Okay, all of that. But here's the kicker: dwelling. If you're going to, if the residential mortgage application has to be in compliance with 202.13 for a certain dwelling related loan, we need to know what that certain dwelling is, okay? And that is, since it has to be in compliance with 202.13, the dwelling in 202.13, that certain dwelling means a residential structure that contains 1 to 4 units, whether or not that structure is attached to real property. The term includes, but is not limited to, an individual condominium or cooperative unit and a mobile or other manufactured home. Whether you see a house in here anywhere, okay, it means a residential structure. I mean, of course, being that it is a residential mortgage transaction, you would think. And here's the kicker: 1 to 4 units. Okay. An advance to a depository institution must be secured to the satisfaction of the Federal Reserve Bank that makes the advance. Satisfactory collateral generally includes United States government and federal agency securities and, if other acceptable quality, mortgage notes covering 1 to 4 family residents. So they need the 1003 form to give us a dwelling that contains 1 to 4 units, so they can use it to get their credit. Okay. But throughout that whole process, that's actually what first of all, let's go to certain dwellings, okay? For certain dwellings, certain means ascertain, means to be clear, precise, identified, okay? Unambiguous, okay? Dwelling means the house, okay? The house or other structure. So basically we know that it's not a house because they're using the other structure. And here's the evidence: a residential structure, and not the house. The house or structure. Okay. Now, the reason why they have to use this 1003 form is because it's a residential mortgage transaction. So this is why they're issuing the 1003 form. Why? It's because there's called right of rescission. If there's anything dealing with a consumer credit, we have a right to rescind. Okay? Have the right to rescind. And I'm going to show you. This is the right to rescind on the closed end credit, right to rescind on the open end. Okay, guys, just don't take my word for it. Do your own research. See that? Okay, we're going to the open end since the 1003 form is an open end revolving credit. Okay, consumer's right to rescind, except as provided in paragraph A1(2) of this section, in a credit plan in which a security interest is or will be retained or acquired in a consumer's principal dwelling. We know what that means. Each consumer whose ownership interest is or will be subject to the security interest shall have the right to rescind each credit extension made under the plan. The plan when the plan is open. A security interest when added or increased to secure an existing plan, and the increase when a credit limit on the plan is increased. Okay. To exercise the right to rescind, the consumer shall notify the creditor of the right of the rescission by mail, telegram, or other means of written communication. Notice is considered when given mailed, or when filed for telegraphic transmissions, or if sent by other means, when delivered to the creditor's designated place of business. Okay? The consumer may exercise the right to rescind until midnight of the third business day following the occurrence described in paragraph A1 of this section that give rise to the right of rescission. Delivery of notice required by paragraph B of this section, or delivery of all material disclosures, whichever occurs last. If the required notice and material disclosures are not delivered, the right to rescind shall expire 3 years after the occurrence, giving rise to the right of rescission upon transfer of all of the consumer's interest in the property, or upon sale of the property, whichever occurs first. In the case of certain administrative proceedings, the rescission period shall be extended in accordance with section 125 of the Act. When more than one consumer has the right to rescind, the exercise of that right by one consumer shall be effective as to all consumers. Okay? You have a right to rescind, people. And here's the effect of the rescission once you do that. Okay? When a customer rescinds a transaction, the security interest giving rise to the right of rescission becomes void. Let me read that again. When a consumer rescinds a transaction, the security interest giving the rise to the right of rescission becomes void, and the customer shall not be liable for any amount, including any finance charge. Within 20 days after receipt of notice of rescission, the creditor shall return any money or property that has been given to anyone in connection with the transaction, and shall take any action necessary to reflect the termination of the security interest. Okay? Termination of the security interest. Okay, guys? There is a right to rescind. But the problem with that is there's an exempt transaction. The right to rescind does not apply to the following: a residential mortgage transaction. Wow. The right to rescind does not apply to the following. A residential mortgage transaction. So being that the fifth in a residential mortgage transaction, so basically they're saying that since they issued you a 1003 form, it would constitute the transaction a residential mortgage transaction. And a residential mortgage transaction is exempt to the right of rescission. So then the question would be, how is it that the courts would not rule, or the court will not rule in favor of the consumer once they prove that the whole transaction from the beginning was fraud and void? Because you do not have a dwelling, you actually have a house. Okay, a house, not a dwelling. Okay, but this all I'm gonna do for today, guys. Y'all do your own research. There's more to come. That's just the tip of the iceberg. Be ready for the next video. It's gonna get good. Peace out.